You're live.
So this is Senate Transportation, and it is Friday, the 24th of April. And we are here to talk about S-261. It's a little unusual because we don't have the bill here, but there's a little cross relationship. And I thought we would start with a statement from the sponsor of the bill, who is a member of this committee, and then we will go into we have a number of people to testify, and I'll take care of that.
Yes. Thank you, Mr. Chair. So yes, I am one of the sponsors, and Senator Gulick was in this committee, and she presented the bill, and I wanted to let you know why we sponsored this bill. We individually had constituents who requested legislation that would allow the ability to have more trails, pedestrian and bike trails with railroads, if at all possible, because that has been done in other places. And that's the purpose of the bill is to increase access. And other states, my constituents heard from folks in Massachusetts. Her constituents are Vermonters who have worked in Burlington and other parts of the state on trails. So that is the purpose of this language. We'll see, where we get to, but I'm glad we're having the conversation. It'd be great if we could work, finish it now, but I don't know if that's possible. But at least we can tee it up for the future, because this is something that many of our constituents are wanting. And as you already know, trails are a great economic development driver. So thank you.
At this point, I did get a request from Dylan to go first, so if no one minds, Dylan.
Thank you, Mr. Chair. The committee members, for the record, Dylan Zwicky with Leon Public Affairs. I'm not here today on behalf of any one particular client, but I do work with a number of entities that are in the utility and telecommunications space, and appreciate the sort of intent behind the bill. The more we think about this, it's kind of an interesting question. Typically, the trial bar and property owners are not always on the same side of liability questions. Often we're sort of arguing for less liability. But I think on this one, as you'll hear from Mr. Vickenberg, we may be aligned on this. The more we think about this bill, the more questions are raised. And I think there are 5 or 6 kind of key areas where there are open questions and areas of concern. The first is, I think that the immunity is a little bit illusory. It doesn't actually solve the liability challenge that it's purporting to address. There is a willful or wanton misconduct exemption in the statute. I do think that there is a difference between, for example, a gas line or a charged power line and a hole in a field in terms of kind of the danger that we're talking about. And just because there's a limitation on liability does not necessarily mean that entities in the utility corridor are going to be exempt from being the subject of a complaint. You would still need to litigate that complaint. It may be under a different standard. That is going to come with a cost, and that cost, especially for entities that are regulated entities, is going to flow through to consumers. So think about your electric or gas bill. That's going to be an upward pressure. The second piece on the liability question is that it would not, in my reading at least, would not preempt federal claims. So many of these entities in the utility space, in addition to our state regulators, have federal regulatory partners. So National Energy Regulatory Commission, the Federal Energy Regulatory Commission. There's a similar transportation board for pipeline safety. So all of those look at some of the facilities that might be in these utility corridors, and I'm not sure whether that would sort of solve the liability question on that front. The second is, as I mentioned earlier, the distinction between a kind of a hole in a farm field or a gate across a class 4 road, for example, is different than what is essentially an industrial activity. We're not talking about farmland or woodlots or ponds. We're really talking about high voltage conductors, third pipelines, pad mount transformers, communications huts. So to put them under the definition of land is, I think, confusing the two fundamentally different risk profiles. Third, I think that the definitions are somewhat loose when you think about utility corridor. As far as I've been able to tell, there's no real definition of utility corridor in Vermont statutes, and so you could think of sort of the right of way along the roadside or along an existing walking path that might be an easement or right of way. There's also much larger transmission corridors. Those are two kind of fundamentally different questions, and I think just would warrant really fine-tuned discussion about what we're talking about here. Adding to that complication is utilities don't always own the corridor. They might have an easement, they might have some other arrangement, and so that further complicates the liability question. As I touched on earlier, the insurance and repair consequences and commercial general liability policies are generally priced on disclosed exposure. Recreational public access across miles of corridor is, I think, materially different exposure than a closed kind of industrial right of way. So I would anticipate seeing premium increases. I think those are going to flow through to regulated entities customers. Many utilities carry large self-insured retentions, and statutory immunity doesn't reduce the self-insured retention exposure. It just means that the claims are litigated under a different legal theory. So all of this flows through to the ratepayer. And I think you would really want to hear from some of the insurers that might provide this type of coverage, how they would look at this and assess the risk and how that would translate into the policy coverage and rates. Another consideration that we think about when we think about other kind of recreational activities in the utility space is utilities are always performing routine vegetation maintenance to make sure that trees aren't falling on power lines. That means interaction between our employees and whether it's bikers or hikers that might be in this path. That creates complications. There's storm recovery. We're going to go in after a major storm event and clean up. And so it is just generally simpler to make sure that the utility corridors are being used for those express purposes. And liability is just one question there, in addition to a host of other questions about access and timing and how those competing uses are going to interact. And the last thing is, I think liability is just one piece of the puzzle, right? It's all well and good to limit liability or to relieve liability, but if there is an instance where an individual is harmed, we're still going to have potential legal challenge there that's going to have to be litigated. And then there's just the pure kind of public perception of entities, for example, that I work with that really don't. It's a real challenge, right? So someone's walking through a utility corridor and is hurt, and then the perception that the company is somehow not liable for that. It's just it's fraught, can be a really serious harm. And so I think there's just so many open questions about the impact that this would have on regulated entities in Vermont. Appreciate the intent, but I think it's a very significant question So I'll just leave it there. I'm happy to make sure. I think most of you have my contact information, but whenever we want to talk about issues pertaining to utilities, always happy to chat and think through what this might look like in the future.
Go ahead.
Thank you. That was very comprehensive. Are you able to provide just a statement so that when we work on this more, we'll understand better, and obviously you'll need to be part of the process.
Sure. Yeah, I can provide kind of those high level areas that we would want to think about.
Great. Thank you.
Okay. Thank you.
Thank you.
I don't you give us just the very high outline of the bill. Sure. And then we'll go into the rest of it.
Morning, for the record. I'm Damian Leonard from the Office of Legislative Counsel. So the bill in front of you is S-261. And what it proposes to do is it proposes to amend the definition of land in our recreational use statute. Recreational use statutes are a subset of statutes that were adopted to provide landowners who opened up their land to public use for recreational purposes with limited liability if they did so for no charge. So they're adopted in a number of states. And currently in Vermont's statute, land includes open and undeveloped land, including paths and trails, water, including springs, streams, rivers, ponds, lakes, and other water courses, fences, and structures and fixtures used to enter or go upon the land, including bridges and walkways. It does not include areas developed for commercial recreational uses, equipment, machinery, or personal property, or structures and fixtures that are not otherwise described. The statute then goes on to provide that an owner shall not be liable for property damage or personal injury sustained by a person who, without consideration, enters or goes upon the owner's land for recreational use, unless the damage or injury is the result of the willful or wanton misconduct of the owner. In other words, unless the owner intentionally engages in misconduct intended to harm the user. The statute does also provide additional protection for equipment, fixtures, machinery, or personal property, meaning that unless the damage or injury is, again, the result of the willful or wanton misconduct of the owner, an owner shall not be liable for property damage or personal injury sustained by a person who, without consideration and without actual permission of the owner, enters or goes upon the owner's land for recreational use and proceeds to enter upon or use equipment, machinery, or personal property or structures or fixtures that are included within the definition. So it essentially is insulating landowners both for if they open up their undeveloped land or the paths and bridges, fences upon their land for people to pass through and cross into the land. And it also protects them if, without their permission, someone then moves off the path and enters a building or goes onto a tractor or something like that. The bill in front of you, S-261, would add to the definition of land railroad property, railroad rights of way, and utility corridors to which public access is permitted. And so this was based on Chapter 21, Section 17C of Massachusetts laws, which provides that a person having interest in land, including structures, buildings, and equipment, including railroad and utility corridors, easements, and rights of way, wetlands, etc., who lawfully permits the public use for recreational, conservation, scientific, etc., without imposing a charge, or who leases the land for such purpose to the state or a political subdivision of the state, shall not be liable for personal injuries or property damage. in the absence of willful, wanton, or reckless conduct by the owner. So in Vermont, there's some cases on this. In general, they've found that if the object that caused injury wasn't placed there with the intent of harming the individual, that the landowner is free from liability. So examples are a fence in a cemetery that an individual climbed a tree and then fell on the fence. The fence was not there for as part of wanton misconduct. It was there to create a boundary around the cemetery. An individual who was riding their ATV down a farm trail that was actually not open to the public and hit a chain that was across the trail and then flagged to keep people out. The farmer wasn't liable. And then the third instance was a homeowners association. They had a road to the beach that was open only to members of the homeowners association, and they were found not liable because it wasn't open to the public. Or they were found not to be under the cover of the statute, excuse me. They were potentially liable. They were found not to be protected by the statute because it wasn't open to the public. So you can kind of see the difference there. Private use, not covered by this. Public use for charge, so going to like Kingdom Trails or Bolton Valley, not covered by this. But public use for no charge, so trail networks in your town where the landowner has provided an easement and doesn't charge for use of the trail would be covered. And this would add railroad and utility rights of way to that. So I think I've run my 5 minutes. Unless you have questions.
Yeah, I will have questions at some point.
Yep, at some
Yep.
point, and I wanted to get a little outline.
Yeah, thank you.
David?
Good morning. David Mickenberg here on behalf of Vermont Association for Justice. Just to be clear at the outset, we do have serious concerns with S261 and would oppose it this time. So just a little background on, we're really focused on when we talk about access, the access to civil justice for people who are innocently injured by the negligence of others. So when somebody is by the dangerous or irresponsible actor, a dangerous irresponsible, they face damages in the form of medical bills, lost wages, pain, and suffering. And the question we have here is not whether those costs are going to be borne by something, but instead who they will be borne by. So oftentimes when we're talking about these liability issues, we think of sort of, oh, we just reduce somebody's liability, somebody gets injured, and somehow magically they're suffering and their bills are going to go away. That is not the case. The real question is it going to be borne by the entity that caused the harm, the negligence, or will be borne by the taxpayers in the form of Medicaid and our social safety net. So we take issues around limiting liability very seriously, and this bill is a pretty extreme version of limitations on people's access to court. So the companies that we're talking about today specifically, as opposed to landowners, and that you are considering this bill immunizing from responsibility, are corporations that can and should be expected to and do have insurance in place to take care of people who are hurt by their actions. In this case, S261 says that in a matter of law, it would be okay for a railroad or utility to act with extreme disregard for safety, sort of the willful and wanton standard that Damien was just addressing, which could cause an innocent person injuries, and their insurance in most cases would be off the hook entirely. This is a really a bill about access to justice. If we're concerned in terms of accessing rail trails about frivolous claims, or the impetus for this bill is about frivolous claims, Vermont already has a pretty tight very tight civil justice system in which frivolous claims are often dismissed. So for instance, we have in Vermont, like many places, Rule 11, civil procedure, which allows judges to sanction attorneys that file baseless claims. Again, Vermont is somewhat unique. In addition, in protecting personal injury defendants, because Vermont is one of a few states in the country that has very high standards for jury verdicts. So to prevail, a plaintiff must convince all 12 jurors that they've proven their case. All but a few other states allow non-unanimous civil verdicts or have a much smaller number of juries to convince. This means a railroad or utilities defendant's insurance only need to get 1 out of 12 votes to prevail. The results in Vermont is that we have one of the least litigious states in the country. So some of the questions that I think you might want to consider before taking up this bill further is questions about how many claims have been paid to innocently hurt individuals on lands of utilities or railroads. What types of due care are they taking in terms of protecting individuals that may be accessing the land? What's the cost of the insurance? How much? What are the safety practices that are in place to ensure that no one will get hurt on the lands? How do utilities and the railroads handle what's known as an attractive nuisance on their lands? So attractive nuisance is something that a child or somebody would be attracted to and want to go toward and potentially injure themselves. What would the cost shift? And I think this is one of the most important issues is what would the cost shift look like? How much would Medicaid, Medicare, other health insurers, our social safety net have to take if somebody was seriously injured on the property of a utility or a railroad and did not have access to the civil justice system because of this extremely high standard. And so I think before moving forward with this bill, there should be the answers to those questions. And generally, we just oppose creating barriers to people having their cases heard in court. And we don't think that while well intended to access, for recreation purposes, we don't think limiting liability is the avenue to do that. And when you do that, when the liability is limited, there are serious consequences for injured Vermonters. And understanding what those consequences are and who will ultimately be responsible for them, I think is critical in this conversation. So
Go ahead.
And I apologize for coming in late. So maybe it was someone's already given this, but can you give me an example? I guess I'm confused. So like I've heard an example of someone has an unmanned or unsecured fence for their railroad, and then a child, worst case scenario, walks through and gets hit by a train or gets injured by the train.
Mhm.
Would they still have would the railroad company still have to compensate or cover with this? Or are you what's an example
Yeah.
you're talking about?
well, unless the railroads or the utilities behavior is essentially intentional,
Oh, okay.
then they would be barred from recovery.
Okay, so unless they said we are purposefully not putting up a fence,
We-
or we have purposely decided to let this fence go to whatever.
Well, I think the better example of what if they were unintended, there was a hole that they were working on
Okay,
and it wasn't intended to harm somebody.
yeah,
Somebody is recreating in the property, they fall in the hole, they hurt themselves. But they were negligent in leaving that hole. There wasn't signage put up. They were doing work and it wasn't, so the standard of care was breached for negligence. Under this scenario, under this legislation, the injured individual would not be able to recover because it wasn't willful and wanton behavior. So, yeah. So this bill goes to the most extreme level of liability protection. It inoculates somebody from from negligence, which is the basic standard that we expect all people to behave, the standard of care under the circumstances. We would want somebody to exercise due care to prevent harm. And so this, under this scenario, somebody would not be able to recover. Yeah.
Interesting. Thank you. So, I presume that you're fine with, or maybe you're not, the existing way that we indemnify property owners.
Well, that was
I mean,
the,
it's just regular property owners.
yeah, I mean, somewhat, I think it's somewhat different
Uh-huh.
because those are individuals, not corporations, that have insurance to cover. And also the nature of the property here, we're talking about railroads.
Right,
and
that's what-
utilities.
That's what I'm thinking,
Yeah.
is
Fine is
is
another-
why you don't want that to be in
Yeah.
this list.
Yes.
Do you know if, I mean, some of the, I mean, we have a lot of trails, right? So, are there instances where people are having, accidents and not getting compensated for it?
I mean-
Is someone tracking that?
Yeah, we don't, I could check with some of the attorneys that we work
Cause that
with.
would be
Yeah,
helpful to know.
there were a few cases that, that Ledge Council just mentioned, where people were denied, as under the underlying statute, none of it,
Yeah,
were denied, recovery as a result of this statute. And I know, I wasn't here for it, but I know that this issue around limiting liability for access to land for private landowners was a huge issue, and there was lots of
Yeah.
debate. and-
oh, yeah, that was like, yeah.
No, this, we're talking, I'm talking like 30 years ago.
Oh,
I assume you were referring to public trails, sorry.
That's what I
Yeah.
thought, yeah, we talked about that a lot.
Yeah,
So let
no,
me just, yeah,
The underlying statute was mentioned. Yeah.
30 something years ago, yeah.
But yeah, the public trails discussion last year.
Right.
Touched on similar issues.
so, just one other question, would you feel more comfortable if the liability was, somewhere between what's proposed here and what doesn't exist now, basically?
I mean, our general rule is that we think that people should act within the standard of care, which is negligence, which is a basic level of reason, a reasonable standard of care. So,
Okay,
and I haven't heard, and I was in Senate Judiciary when this bill came up. I haven't heard that the sort of reason why we need to limit people's access to the civil justice system to have trails. That's the part that, and so I think insurance is a great tool. And if people want to get insured to insure themselves against claims, then that's a good thing. And you can work that within that system. I don't think we need to limit people's access to the courts to do that. So,
all right, that's good to know.
Yeah.
If you can stay for the whole testimony, that would be great.
Sure.
Here,
happy to hear more.
thank you.
Thank you.
Thank you.
Thanks so much.
Peter?
Sure, thank you. Mr. Chairman, members of the committee, for the record, Peter Young, General Counsel for Vermont Rail. I appreciate you allowing us the opportunity to testify on S-261 off of the railroad's perspective here. We do not come and see this as an issue about liability, legal liability. We see this as presenting a real safety concern for the railroads, likely for the utilities for the same reason identified earlier. This is not language that we've looked for. We don't see the language in this bill as necessary or appropriate. And in fact, we see this as presenting a real safety concern if it in any way encourages members of the public to look at railroad tracks, bridges, rights of ways as a place where they should be allowed to recreate for any reason. From the railroad's perspective, we have trains in some of these railroad tracks, Amtrak moving at relatively high speeds. Freight trains move faster and quieter than many members of the public or folks out in the area expect. And we spend a lot of time, effort, and work closely with, for instance, Operation Lifesaver and others to promote safety in and around trains. You mentioned children in your example. Operation Lifesaver spends a lot of time and effort in the schools teaching children about safety and staying away from the tracks and the danger presented. Exactly for some of the reasons you mentioned. A lot of the children, adults also, are very intrigued by the trains. They like to get up close. They like to see what's going on. That's a danger. We see that as a very high risk activity. And it's not just for the risks to the members of the public who are out, but it also has a significant impact on train crew. As you all know, locomotive engineers can't turn the train to avoid a hazard, whether it's on the track, whether it's a person. And very often there's no such thing as a quick stop. And most likely there's going to be a collision, an impact, and the likelihood of fatality is very high. And that's not just because of the trains, which run on the freight lines, not always with a consistent schedule, but there is also railroad maintenance equipment, high rails, but also vegetation equipment that's out there with cutting and maintaining the right of way. We have other equipment out there at all times. Speaking for Vermont Rail, we operate year round in all weather, all times of day. And it's why when Operation Lifesaver is out in the community, the message to the members of the public are see tracks, think train. We do not see anything that would encourage the public to consider railroad tracks or a railroad bridge or a right of way to be a safe place or an appropriate place to spend any time. We work closely with contractors, municipalities to make sure that whenever there's any construction work anywhere nearby, whether at a crossing or a culvert or track work, that we have appropriately trained contractors with insurance, that our dispatch is aware, that we are able to notify train crews. There are signs up allowing people to call in case of emergencies. We have people on the track providing flagging services. All of this goes to focus on keeping people safe. So it's not just about whether or not somebody is killed, whether the railroad will have to make a payment. That's not really our focus. Having people out on the right of way puts them at risk. And anything that would encourage them to be out there, except in very structured, limited circumstances, we think is not consistent with safe operation of the railroads. And go even beyond that, something that most members of the public aren't thinking about, is it's not just the area directly on the tracks. Railroads move wide loads. Railroads often have, a wider impact along the right of way when a train goes by. So it is not simply okay to step back 8 feet from the edge of the track so you can get a nice close rush when the train goes by. That's a threat. That's a real threat to the public, whether it's children or adults, or somebody who's out wearing earphones on the train. Nationwide, there are far too many fatalities on a very regular basis from people who do not treat the tracks as the threat they should. So from our perspective, to minimize fatalities, minimize the impact on the train crew and the operations, and minimize the risk of derailments that come from efforts to have a sudden stop or something along those lines. We do not favor anything that's going to encourage public access in the right of way. We are always happy to have conversations all the time with folks who are interested in having access, crossing agreements, things like that. And we're glad to be part of any conversations, but we would not like to see 261 move forward as it's presently drafted.
Go ahead.
Thank you, Mr. So I appreciate that. And if I'm understanding the purpose of the bill correctly, it's to help create and allow for a park, at least 2 different locations or recreation areas to be built. So if it's not the removal of liability that's holding back these projects, what is?
I'm not aware of specific projects that are involved. as I said, there are certain opportunities where there's a structured, the structure in place for responsibility, for public, for access, egress, that there's ways to do that.
Okay.
What we don't want to do is give people encouragement that, oh, this says, railroad structures are okay to use. Well, there's a lot of bridges over waterways. We already have fishing season. People who look at bridges as a way to access a favorite fishing spot, as a shortcut. That is not safe, and we do not want to see it. And the movie Stand By Me notwithstanding, that's done more damage probably to the idea of what a great way to shortcut through the woods than anything else. No disrespect to the movie, great movie. But we really want to emphasize it for the public and for those who are out there that seeing tracks is not an invitation for a shortcut or a hiking trail or a fishing access, that it really is a place to stay away from. So in this context, anything that would encourage recreational use or people to believe they had recreational use is our concern. It's a safety issue from our point of view and not really the issue of the liability language.
Yes, well, and this committee has been talking about safety all year, and we're gonna keep talking about safety. So just a couple of things. Folks, there are places where rails and trails do work together. It's not easy to do. And so we will be having more conversations, but it does happen. It can happen. There are situations, in some cases, it's better to have something be used properly and intentionally rather than have people on the right of way random, right? Or without controls. I mean, that has happened.
We don't disagree. And with a structure in place with the appropriate parties involved, it is possible. Not always, but is it
Yeah.
possible in some locations to have that kind of context and put that in place? And there are places, yes.
Right, but it has to be deliberate and it has to be, it's a process. It's not easy, but it is possible.
Yes, and it is very particular to the land available.
Sure.
If, then it depends on the width of the right of way, which
Right.
historically varies in a lot of different places. And that's why we're always able to pick up the phone, call or answer a call and discuss when people have particular questions or concerns about activities near the railroad.
Right,
But we start the conversation always about safety
of course.
for the
of
public,
course.
for the train crew, and for the community.
And we do too. There's something I've been wanting to talk to the railroads about that I just realized those little blue signs,
Yes.
people don't know what those are. I talked to, okay. So at a railroad crossing, there's a blue sign that has information on it where if there's a problem, like if there's a train stuck or a car stuck on the track, they're about this big and people don't know what they are. So a project maybe could be to have larger signs, so that, and that say, if there's a problem, call, and I'm sure it's a federal regulation, it's probably already set at that size, but from my experience, it's not as safe as it could be.
It's one of the things that, if you'll allow me a moment more, Mr. Chairman. It's one of the things that I know that comes up in driver education training classes that the state supports, about safe operations near railroad tracks, Operation Lifesaver Rings. They have a different official name. We call them blue signs.
Yeah, that's my note,
The-
blue sign.
The FRA requires every crossing to have a very specific sign.
Yep,
And yes, size, type,
it's about
everything this big, every crossing,
Yeah.
and it's gonna have a specific number to identify the crossing
right,
and a specific number that goes straight to dispatch of the train.
Yep.
So if you are at a crossing and there's a blue sign and you have an issue, you pick it up and you say, car is stuck on a crossing. And it goes straight to dispatch radios train crew in the area, and we know, stop the train.
right,
It doesn't happen in a heartbeat, but that train, that call goes 24 hours a day to a monitored dispatch,
right,
and that's there. And we do think that that's part of the messaging for the public. And it happens plenty of time that
Make-
people make those calls.
Make the
Yes.
site, make the signs bigger, please.
I would like to say yes, but I think the federal government is very particular on what is an allowed.
It might
sign.
be at
But
least this, that might be, so,
we'll look into it
Okay.
for sure. But yes, that's on every
I
nationwide,
know,
every crossing.
I know, and I tell people about it. And generally, the people don't already,
And I know it's in the driver education course because one of my kids came home and was like, hey.
yeah, look at the railroad thing, probably.
That's right.
He's alert to
I-
railroads. Okay, so I'll stop there.
I think we'll
Yeah.
get the sign.
Yeah.
Any other question? Thank you.
Thank you.
And if you can stay to hear the others, that,
I will endeavor.
or you.
I will
can-
try, yes.
Or you can look at the tape recording.
Rick?
Yep.
You need your name and who you're representing and you're on.
Okay. My name is Rick Sharp. I've been involved with a number of people in southern Vermont, mainly from Bellows Falls, Brattleboro, about forming a group that we're calling Friends of the Connecticut River Valley Trail. And that is the idea to create a pedestrian pathway, pedestrian bike path from the Mass border to Canada along the Connecticut River up through there. There was a study done by VTrans 2024 in which they surveyed all the towns along the Route 5 corridor between the Mass border and Canada, and found that every town, without exception, along the way there is in favor of a pedestrian bicycle path along that corridor. So we are forming in order to try to move that along. There was a recommendation at the time that they form a steering committee to create that pathway. That steering committee has not been created to date. So we have formed the Friends of the Connecticut River Valley Trail instead to try to move it along until the steering committee is put into place and we can get some progress on creating a trail. It is my opinion that we've looked mostly along the Connecticut River between Bellows Falls and the Mass border. And it's very obvious that a trail running through that area would have to work with Route 5 and the railroad as well. And in a lot of places, that trail would run right alongside the railroad. And I heard the testimony of the gentleman from the railroad there earlier today. Certainly, we want a safe pathway, one in which people are not going to be wandering onto the tracks and getting hurt. So we certainly, that's the number one thing, is to have a safe pathway. But it will be necessary to be very close to the railroad at some points, and very close to Route 5 as we figure out where exactly this goes. So we are in favor of the Rails with Trails legislation to allow that kind of trail to be created. And my bet is that without it, it cannot be created. Although it's interesting to hear today that the railroad doesn't seem to want legislation. Maybe we can talk to Craig Della Penna about his experience in Massachusetts and why this type of legislation is necessary. Our legislation here really is modeled after the Mass legislation and the Maine legislation, both of which have passed enactments like this in order to get the railroads to allow trails right alongside the railroad. Might also point out that there are a number of places here right now where bicycle paths run right next to the railroad tracks. Burlington's a perfect example of that. There's a chain link fence in between the railroad and the bike path for most of that distance, but there are areas where a pedestrian can walk across the tracks. Down at Lakeside, for instance, there's no control on it, but there is an opening in the fence that will allow you to go across a existing track. So this has been done. We already have these situations going on. I'm not aware of any injuries that have occurred, and I would suggest that before you make a final decision on this legislation, find out if there are problems with having individuals near railroad tracks, what has been the experience so far? Because my bet is that it's there are very few instances of that. So, in my opinion, this kind of legislation would be necessary to create the Connecticut River Trail that we're talking about. And I'm hoping that you'll find a way to satisfy all the various different parties. We would certainly work closely with the railroad to do something like this, but I think it's time to create the Connecticut River Valley Trail. Thank you.
Thank you. Senator White.
Thank you, and Rick, it's lovely to see you on Zoom. Thank you for coming. I'm obviously a big supporter of rail trails and especially a Connecticut River-based rail trail. But I'm feeling like I'm having a bit of like disconnection between this bill resolving conflicts with the creation of that trail. So I look forward to hearing from Mr. Della Penna. But I'm wondering because the bill also includes utility companies, is my understanding. I think we're hearing later from the utilities as well. Maybe I'm wrong.
I heard earlier.
Oh, you did? Oh, sorry, I just missed it. Oh, okay. So I'm wondering, we're talking a lot about rail, but there's also like gonna be power lines and everything. So are utilities also on this trail, or kind of why include them?
I think there are utility lines running on near a lot of railroads. And there's very, that stretch is almost 100 miles long from Mass to the Canadian border. So there are going to be various different spots that you're going to be near this railroad or that railroad or a utility. But what I would suggest that if you're very concerned about those kind of things, what has been the experience to date? How many lawsuits have there been? How many negligence situations have there been with utilities or with railroads that have created injury to individuals? My bet is that it's extremely small. There isn't a lot of it. I have a hard time even imagining how a utility ends up being in a spot of negligence, other than if they're trimming, brush along the way or something, and somebody gets into their equipment or something like that. So that'd be the only thing I would say might result in some type of negligence. So.
Okay, so there are utilities and everything.
Other questions? Thank you, Mr. Sheriff.
Thank you.
Thank you very much. Craig? We're ready for you.
I think you're still muted. There you go.
All right. Can you hear me okay?
We can.
Okay. Can I share my screen?
Yes.
Yes.
Okay. You've seen the big rail yard there, the lumber yard. My name is Craig Della Penna. For 30 years, I've been involved in the rail to trail projects throughout the Northeast United States. I used to market rail freight, plan the startup and manage the operations of 7 large-scale transloading operations. The picture you see there is actually in Connecticut. It was the largest single wholesaler lumber reload terminal in the Northeast United States. The mainline track there next to it is the old Central Vermont Railroad. From St. Albans, actually into Canada, St. Albans, and all the way to New London, Connecticut. This was along the way. I was invited, I actually also worked for Pinsley Railroad Company, the last real railroad that ran the St. Johnsbury and Lamoille County line up until the 70s. And I was invited to write a series of books about rail trails with a real serious bent towards the history. And then I got involved with the politics of how they did or did not get built. And I was actually hired as a lobbyist organizer in 6 states by Rails to Trails Conservancy. And I would parachute into all the to-dos about, shall we build the trail or not? So I'm sort of battle hardened. I'm the annoying Rain Man of rail trails, but I'm also like Forrest Gump, passing through iconic events we never knew were iconic at the time, including I was on the team that created the first report for the Federal Railroad Administration and the Federal Highway Administration, who partnered together to do a report about rail with trail over 20 years ago. At that time, the Federal Railroad Administration was very concerned because there was about 60 of these places there. And they wanted to streamline how they got built or didn't. They wanted to understand why they were needed and what was going on with that. Later, Rails to Trails Conservancy has done several more reports on this subject. And in fact, I was hired by Rails to Trails Conservancy part-time in 1997 while working for Railroad Distribution Services doing my big transload operations. And they brought on board Charlie Marshall. Charlie Marshall was the founder of the Genesee and Wyoming Railroad Company, a salt mine railroad company in upstate New York, that he expanded and became the world's largest aggregator of short line railroads. Over 120 railroads now, if I'm not mistaken. Charlie is on the board of Rails to Trails Conservancy. And this thing I have on the screen here, the Senate committee has this and can send it to you all as a link. And I'm going to scroll through it here. That's Charlie Marshall. Several of the railroads he owns or ran, he was the president, I should say. He actually was involved in rail to trail development where they made sense to ensure they made sense, not frivolous, lightly designed and frivolous, scary, unsafe places. No, Charlie Marshall was very detail oriented and he was on the board for many years. He just got off the board a couple of years ago. This little snippet on Rails to Trails Conservancy's website honors Charlie and his work. You can see that. Now, one of the railroads that the Genesee and Wyoming Railroad now owns is the old Central Vermont, more recently known as New England Central Railroad, the one that comes up the Connecticut River Valley. They don't allow rail with trail because the state of Vermont has not changed the rules yet. Now I'm going to take you to another site here. This is one of my websites, and the Senate team has this here as well. And
I don't
there's a
think
lot of.
we can't see what you're
We
doing.
can't see your,
I'm sorry, say it again.
we can't see your, it's not up.
This is not showing.
We're not seeing your screen.
You're not sure.
Yeah,
Did you see this one?
Neither.
No.
it's been the same, but you can also send us things. And
Well, I
we'll,
did send this to you.
oh, great. Charlotte, you see it?
Yeah,
right
here on your
Let me go on to Zoom here. Maybe
Okay.
I
We,
have to do it this way.
we can actually look at it on our laptops while you're
Okay.
talking. Oh, yeah, I see the website.
Share screen. Share screen. Let's see. Can you see it now?
No.
Oh, let me press share. How
Oh,
about now?
yes, now it's happening.
Okay, yes, this is
There you go.
this is the screen about Charlie Marshall and his work for several years. He was on the board of directors and the president of the board of directors of Rails to Trails Conservancy to ensure that rail with trail projects got built safely and sanely. There's over 400 now. And I'm going to switch to this screen now. Can you see this screen?
Yes.
Yes.
Okay, this is one of my websites. I have a number of things here. Let me see if I can make that smaller. Yes. This is one of my websites, and you have that link as what I presented to the Senate committee here last night. This one here, click on that. This is Genesee and Wyoming railroads with setbacks, specifications, locations nearby in the Northeast where they have rail with trail projects. Just scrolling down, you're going to see numerous numerous rail with trail projects. Massachusetts. I've got 3 lectures coming up on Cape Cod. This has been in the ground for 40 years. They don't even have a fence on it there, but these are the full spectrum of what kind of rails with trails there are. This is
Oh, there's the Northampton. Can you stop on the Northampton one?
That's it right there. I'm actually about a mile from that. My wife and I own a house, a Civil War era house that sits 8 feet from one of the earliest municipally built rail trails in the United States. And we operate a bed and breakfast here. And I'm a realtor in my day job now. I'm the first realtor in the United States specializing in the sale of houses near rail trails. And let me get back to the main screen here. Go back to this. Here is the workup, the little light blue item here is the module for the Massachusetts legislature in 2008 that created and passed the rec use statutes, which you're modeling. This was modeled after what happened in Maine. In Maine, what happened was the senior vice president of Guilford, as they were becoming Pan Am Railways, met with the lobbyists for the Maine Railroad Association in his house in Portland or South Portland with attorneys and principal people with the Eastern Trail Alliance. This was in 2005. And they hammered out the specs on how the rec use statutes could change.
You froze.
In Maine. Oh,
You're back.
is it okay now?
Yeah.
In Maine, they did the first updated rec use statutes in New England because the leadership of the executive vice president at Guilford Rail, who, by the way, are you all sitting down? He's been elevated when CSX bought Pan Am. He now has a new job. He's the head of the Federal Railroad Administration. That is to say, the guy who was in the background getting the main rec use statutes to allow rail with trail, and in Massachusetts, which they partnered with National Grid, who owns 200 miles of dead railroads converted to utility corridors. Together, they created the Massachusetts improved rec use statutes. And that was in 2009. Now, this fellow is the head of the Federal Railroad Administration and just had a big event with the Short Line Railroad Association about how the feds are going to be using AI-driven protocols to inspect tracks. So it'll be a little cheaper, won't have to use so much manpower to do that. But he is still involved with cutting-edge stuff. This isn't easy, I know that. But it's not for frivolous little crazy purposes. These are very important because the densest network of dead steam railroad corridor, I'm not talking about trolley lines, but I'm only talking about dead corridors here. But the densest network is within 150 miles where I'm sitting right now. And we need to make these places more robust by rebuilding these old lines into linear parks. There will be gaps in some of these linear parks that need to be filled by rail with trail. They're not to be frivolous, not thought about frivolously. They have to be done carefully and thoughtfully, and you have to provide the railroads with the legislation to make them at least feel tangentially comfortable. And this is important because I've commissioned in the last 3 years 2 major reports that have never been asked before in New England. What the hell is this stuff worth? For 50 years, we've been pouring in relatively small grants and sometimes large grants to reassemble these corridors into linear parks. There are gaps. In Vermont, talking about what Attorney Sharp just mentioning down in the Brattleboro area, the old 36 miles of trouble, the West River Railroad coming north out of Brattleboro alongside the Central Vermont line going all the way up into the Londonderry area. That is built out in Londonderry there's a gap in downtown Brattleboro to the Fort Hill branch of the B&M Railroad. That gap needs to be filled with a rail with trail. There are scores of trespassers there every day. I would like to see the Vermont improve the rec use statutes to allow for this in a thoughtful, careful way. Nobody's asking you to go in all hands on deck. Do a demonstrator project. Do it slowly, carefully, and it's happening all over the country. These are they're thoughtfully done. They're not frivolous. I'm very excited to hear you today. Here's things about Pinsley Railroad Company. Pinsley, they just went out of business. They were picked up by CSX. A couple of executives inside CSX now have the Pinsley Railroad Company branding, logo, everything. And here's other examples on this site also of other states' recreational use statutes. And you can see Connecticut here. I've got to update this. I think they've updated theirs. Vermont is not contemporary standards. And you see this here. New Hampshire has contemporary standards compared to Vermont. Well, that's a problem. And so there's things to do here. So thank you. I'd be happy to answer some questions if you had any.
Questions? Go ahead.
So I guess I'm still confused because, and thank you, Mr. Della Pena, and I'm appreciative of you bringing up in memorial your friend, it sounds like. But I'm confused. It seems like we also do have rail trails. Massachusetts has rail trails. I guess I'm confused about like why this law needs to be passed based on the fact that we've heard from the rail folks and others that they don't want it or need it here. Like, what is the actual barrier then to these being built? I guess that's my confusion.
Well, the confusion is because when governmental entities, and there's been a couple of instances just on the old Central Vermont now, New England Central Railroad, which is part of the siloed 120 railroads under the flag of Genesee and Wyoming. The railroad officials who are local say, "Oh, we don't allow that because I never heard of such a thing, and we don't allow that." But in reality, they do. And so it has to be sort of like telling the railroads from the top down position that we want to do this and we want to work together. And it's important to fill the gaps because, and I didn't really flesh this out, the reports we produce show that when trails become long, the experience in New England is always numerous. They're everywhere. These rail to trail projects are numerous and everywhere, but they're not long because the gaps are expensive to fill or they're complicated, as in rail with trail. Having trails that are long presents opportunities for long distance overnight journeys that is transformative for the economic impact. Here in Massachusetts, the third largest industry is tourism. They're just putting their toes into the water of long distance bike tourism. We will have the longest rail to trail project in New England is not the Lamoille Valley Rail Trail, by the way, which I wrote a 2,000-word piece to your Hardwick, Vermont newspaper 20 years ago that tipped the scales, that got Agency of Transportation to green light the creation of that as a trail and not try to keep it running as a pretend railroad. It doesn't work. I know how to make railroads work. Other people do too. Places that don't need to become trails. Once they become long, multi-day journeys, they're going to be worth on the order of $2 million per mile per year that will go into communities that are frail and forlorn in some cases, that will cause a renaissance into places. And that's what it's all about, really, is the economic impact. And we all know the health impacts of having outdoor recreational, the benefits there, but the real insightful things for state agencies is, well, what the hell is it all worth? And it's very compelling stuff. In fact, I'd love to come up sometime and do a proper presentation. These are even the utilities. Someone mentioned earlier, one of your earlier speakers mentioned just tangentially gas pipelines. The Unitil utility in Maine has a 700 PSI gas pipeline in the trail that they loved the idea of having refuse statutes there so other trails could connect to this to have more eyes on the trail. They wanted more eyes with regular people that would prevent any bad things happening to their pipeline. That's part of the equation here too. In Massachusetts, there's one utility, National Grid, that owns over 200 miles of former railroad corridor that is becoming trails. And the bill signing ceremony that they were in the background with Pan Am Railways years ago, that at the bill signing ceremony in Boston with Governor Patrick in 2009, the entire real estate department of National Grid was there. And wherever there's a ribbon cutting for even a short few 100-yard section of a trail of a utility corridor they own, that used to be a railroad, their real estate department is there. This is very impactful. This is important for Vermont too. Here, you have several places in Vermont, as Attorney Sharp just mentioned, the possibility of bits and pieces of corridor that would have to be rail with trail to fill gaps where it's not possible to be having a trail along the road for whatever reason. And so, I'm just thrilled that you're doing this now. This is very inspiring.
Yeah. I would just say, I appreciate your point, and I think I'm still struggling to follow along a little bit, so I apologize. But is your point that like the gas companies want people to be walking on their pipeline corridor and that their preference is to have that because the more people who are viewing it, the more likely they are to notice leaks? Like, I guess that seems a little illogical to me, because then if we remove the liability and then someone got hurt, who noticed a leak or was injured by something, they wouldn't be able to have any kind of protection, is my understanding from this law. So I don't think it's worthwhile to have citizens be asked to be sleuths for utility problems when they have liability. So
all these things on this page they go to links to fill in the gaps in your knowledge here. I can't do this just on a few minutes here. This page will illustrate everything for you. This is exactly true. Unitil, 700 PSI gas pipeline in southern Maine, were involved to get the trail built. They wanted the trail. Case closed. This is true. This will all explain it here.
Sure. No. I guess I can agree. I really appreciate that you have your website and you've made stuff, and I'll definitely review that. And thank you, Senator Harrison, for bringing this forward. But I think that is phenomenal that they're so excited. And what I've heard from, I think, our utilities in the rail already is that they are supportive of rail trails, but they don't necessarily see the need to remove their own liability to achieve that. And I worry that the argument you're making is that folks should be viewing and looking at utilities when they're on these rail trails. That's a benefit to these companies. But then my concern is with this bill, we're removing all their ability if something went wrong. Like if they did identify a fallen wire and got electrocuted, they have no ability to get any remittance with this.
Well, yeah, I mean, this is a longer conversation. Part of it is that when you have more eyes on the ground in any situation, not just this, and people, they're not trying to act, have the people act for them.
Okay.
But it's a safer situation for everyone. Like, we were talking about kids on the rails. If there's a whole family there with kids, they'll make sure the kids don't go on the rails, which is much better than having like teenagers going out on their own and being the only ones around.
Okay.
So
I can figure out.
so that's, I mean, we can talk more about the liability, obviously. I mean, we will, but,
Yeah.
but having spaces be public and visible is generally safer than hideaway spots.
I'll just close with my point, my part here, and say that I'll be available for you to do research and answer questions, and I will feed your committee lots of information as I come upon it and be a resource for you.
Thank you.
Well, thank you very much, and this has been helpful for us to learn about this issue. And I think we have a ways to go, but thanks for getting us started on this path. Thank you all. And with that, Megan,